Listen to the voices of the advocates.
Geoff Budlender SC is at the Cape Town and Joburg Bar in South Africa. He is a human rights advocate with clients ranging from the government to social justice organizations. In 1979, he co-founded the Legal Resources Center, a public interest and human rights legal service for marginalized populations in South Africa. During his time there, he undertook cases involving the victims of apartheid laws, the forced removal of communities, and detention without trial. Geoff has had a remarkable career at the bar. Join me as I speak to him on his life and the law, including his friendship with one of the leading lights of the anti-apartheid movement, Steve Biko. We hope you enjoy this episode. First, let me just say thank you to Geoff Budlender SC of the South African Bar for being with us on this episode of Advocates, the podcast. Welcome, Geoff.
Hi, thank you very much. Happy to be with you.
Geoff, let's just dive straight in. And where we normally start is with a little bit about your background and your history and your family. Could you tell us a little bit about that?
I'm South African born in a small industrial town. Had a very standard, typical white middle class upbringing. Attended a good school and a good university, but I grew up in the same circumstances as most South Africans, where my contact with black South Africans was very limited, and certainly nothing outside the traditional relationships of dominance between white and black and segregation. So it was a very traditional upbringing in that sense, although my parents were liberal-minded people.
And brothers, sisters?
One older sister, one younger sister, both still in South Africa.
And what do they do?
One of my younger sister is an activist of note. She's a social researcher, was a trade unionist, was banned under the security legislation. My older sister was a nursery school teacher and is now retired.
Wow. Okay. Let me ask you a little bit about your parents. You say, white, liberal-minded. I've read that they were members of the Progressive Party.
That's correct.
What did that entail?
Well, the Progressive Party was the most liberal, the only liberal opposition in Parliament. It was represented for most of the relevant time by just one member of Parliament, a famous woman named Helen Suzman. And they were standard party members. There were small party meetings at the House. They didn't involve having to stick their necks out to any substantial extent, but they joined the party when it was formed, I think, in 1959. So they brought us up with those sorts of basic values.
And what did you observe in those party meetings as a child you think influenced you later on growing up?
Not very much. I saw people like my parents, like-minded people. They all seemed quite affable. It's all very civilized and genteel. And,
right.
They were basically tea parties. There's some member some prominent person in the party would come and speak to a group. I remember the leader of the party came once and spoke at our house, and there would be 20 or 30 people who would sit around and chat and have tea, and it was nothing very remarkable. It was within the parliamentary system, and so it wasn't challenging in any material sense to the structures of what was going on.
We have listeners from all over the world, and I'm interested in the words you used about having a traditional relationship with black South Africans at that time. Can you describe what sort of relationship that is?
Yes. Well, one has to remember, take a step back. South Africa was segregated by law. And so there was segregation at birth in the maternity home or the hospital or the nursing home. There was segregation at nursery school. There was segregation at primary school, at high school. There was, and university. There were, with limited exceptions. There was residential segregation. There was segregation all the way to the time of death. There was segregation in the cemeteries. All of this enforced by law. And in the workplace, there were relationships of dominance. The workplace couldn't be fully segregated. It was impossible. Black labor was needed and white bosses were needed. I mean, I can't think of instances when I was growing up when one had white people in positions of subordination to black people giving instructions to white people. It was just not thought of. In the home, there were black domestic workers and white bosses. And so the entire relationship was one of dominance and control and segregation. Critically, the only people you would meet would be those who were your social subordinates and economic subordinates, and who there was no notion of equality anywhere really. There were pockets of the society which were different, but a traditional white South African growing up in a traditional way didn't see any of that at all.
Your activism later on in your career is well documented, but I'd just like to sort of press a little bit more about your childhood and whether, coming from that background with liberal parents, was there a time during your childhood when you did sort of look at this segregation and go, that's not right? It's clear to me it's not right.
I grew up knowing that it was wrong, but in a somewhat abstracted intellectual sense. It didn't impact on my life in any way, except that I was in charge. And it was really only when I came to engage politically and came to engage with black South Africans politically that it started to have an impact. And then, of course, in my professional work, for the first time, I saw firsthand and experienced what black South Africans went through in their daily lives. It was, for example, one of the critical parts of my life was the struggle against the pass laws, which restricted the movement of Africans within South Africa, which split up black families. Mainly the only black people, African people who were allowed in the cities were those who were ministering to the white economy or the white-run economy. That was mainly men. Wives and children had to remain in the rural areas where the husband or father could see them once a year on a visit. And the pass laws were a rigidly and cruelly enforced system which broke families apart every day. Now, I knew about that when I was a student, but I never really knew about it until I started working in that area. And my clients were the people who were the victims of the system and whom I was seeing in my office and seeing in their lives. And that gave me quite a different understanding of what was going on in the country. So I grew up knowing about some of these things, but I knew about them in a somewhat abstract intellectual sense because whites were, if they chose to be, easily insulated from it, or put it differently, they were insulated from it unless they made a conscious decision to break out of that insulation.
Let's turn now to university. Tell us a little bit about your initial foray into another area that wasn't law.
Very unsuccessful foray. I started as a medical student at the University of Cape Town. I discovered A, that I wasn't very good at it, B, that I wasn't interested in it. The scales really fell from my eyes when a friend with whom I was sharing a house, fellow student, who was studying law, said to me one evening, "Have you noticed that you're more interested in what I'm doing than what you're doing?" And I hadn't actually noticed. He had noticed.
That's a classic.
It was a wake-up moment, and I decided eventually that I must get out of the medicine and get into law. Also, I was interested in the law because I was involved in student anti-apartheid activities, and I saw there the power of the law actually in protecting people who were engaging in activism, people like me. It was clear that the law was something which could have a big influence on what was going on around us. And so I became fascinated by it and decided that was a much more useful thing to do than being a rather poor doctor.
I'm interested in, at that time at university, can you point to sort of one thing that happened within the judicial system, the legal system, that made you think, yeah, the law can actually make things change?
Well, there were very big student protests at the University of Cape Town when I was president of the Students' Representative Council. And students were arrested and they were assaulted and they were beaten up. And the law ultimately came to their protection. They had to be released. Those who were prosecuted were acquitted ultimately. Some of the regulations governing the meetings were set aside by the courts, and those who were assaulted could bring damages claims against the police. That was part of the paradox of South Africa, that there was a functioning legal system in some parts, and the legal system had a measure of independence in some parts. And it was that paradox. It was the paradox of a system in which there was parliamentary supremacy. Parliament could make any law it liked. There was no constitution to restrain it. the government appointed the judges. There were lots of political appointments of judges. The whole system was under the control of the executive, effectively. Yet, there was a certain measure, and lots of the judges were racist, and most of the judges all of them were white men, bar one. There was one white woman. And they came to it with all the inherited prejudices of white South Africans. Yet, there was a measure of independence and space which one could perhaps exploit. That's what I thought. And that's really why I became interested in the law.
And I'm really interested in that because you say there's some measure, you use those words very carefully. And I'm wondering whether, looking back now, how do you account for that? Bar one, they're all white men, all appointed by the executive. How do you account for that small measure of independence?
Well, it had something to do with legal culture. I mean, it's a very interesting question you're raising. Some people say that it has something to do with Calvinism, but I don't understand that philosophy, so I don't. But those who know about it may say that's true or false. But the Afrikaner nationalist tradition and the white tradition generally was a tradition of, well, take the white tradition generally, there was a tradition of independent courts going back quite a long time, back into the 19th century, that you would get courts giving judgments against those in power. We had absorbed, we thought that we had absorbed at least the English legal system, or parts of the English legal system. The courts drew very heavily on English law for their authorities. And so there was a culture in the system which said the courts ought to be independent and ought to hold a power accountable. There was a famous story of what the National Party government, which ruled South Africa for most of the relevant period, came into office in 1948, the Afrikaner government. And one of the first things they did was they implemented affirmative action in the appointment of judges, because most of the judges were from the English side of the white community. And they very actively and deliberately appointed a lot of Afrikaner judges and made no bones about it. And they also appointed judges who would be politically compliant, they hoped. And there was a famous statement by a Minister of Justice who said that, one of the nationalist ministers of justice, who said the problem with judges is you appoint them you appoint them because of who they are, and within a short time they think they were appointed on merit. And they then start behaving like that. That was the culture of the judiciary. And It is a culture which has been sustained over a very long period. It's a very peculiar thing. And that's what created the space. We also had a relatively independent legal profession, which is very important. Particularly the advocates were independent. The attorneys, we have a split system here. Attorneys or solicitors and advocates or barristers. And particularly the advocates were quite independent of the system. The attorneys less so, but even to some extent. And of course the judges in those days came all from the advocates, almost all of them. And so there was a culture in the legal system which created a surprising space for activity.
That's really interesting. Let me now turn to the beginning of your activism, and I guess like anyone looking for good trouble, you joined the National Union of Students and rose very high there. I'd like to spend a little bit of time speaking about your relationship with Steve Biko. So tell us how that came about, and tell us a little bit about the man.
Well, Steve Biko was an extraordinary man. He was a very big influence in my life. For those who don't know, Steve Biko was the leader of, I was one of the leaders, although at that time a very relatively junior person in the National Union of Students, NUSAS, which was supposedly legally a non-racial organization, but actually white-dominated for a variety of reasons, including just pure numbers. Steve Biko was in NUSAS, but he and a group of fellow black students formed an organization called SASO, the South African Student Organization, which was a black consciousness organization. They said black people had to organize on their own. They had to get themselves together, organize themselves, express their blackness and express their power, and then deal with white people from a position of power rather than being submerged in white-led organizations. Now, I got involved in NUSAS in, I think, late 1970, and the first NUSAS event I attended was the last one, the Sasso people attended. So we just coincided in student politics. And at the end of it, the meeting was in Cape Town. At the end of it, I was going home to Port Elizabeth, my hometown, which was about 500 miles away. And when Steve heard that I was doing that, he said, he wanted to go to Port Elizabeth. Could I give him a lift in my car? And I said, of course. I was very bowled over because he was already a great man. I was very junior. Anyway, so we spent the whole day in the car together, driving on our own, two of us between Port Elizabeth and Cape Town and Port Elizabeth, 10 hours. And that became the foundation of a friendship. He was an extraordinary human being. He was very pro-black, and there wasn't a bone or muscle or anything in his body which was anti-white. He could draw that distinction, and he drew it effortlessly. So you could have white friends with whom he could engage with ease, but at the same time, he was very militantly pro-black consciousness, saying we have to have a separate organization. And so that was the beginning of our friendship, and then we maintained contact over the years until he was finally killed when he was in detention, not that many years later. But he was a powerful intellect. He transformed not just student politics, but he had a much wider influence on the society, and he was an extraordinary political figure and also an extraordinary human being, a great charisma. Here, I'll tell you a story about it. We were driving from Cape Town to Port Elizabeth. As we approached Port Elizabeth, and I made sure, of course, that he understood during the course of this trip that I was not like other white people, and I was really quite different, and I was radical, and I was switched on. And as we came towards Port Elizabeth, I said, "Where would you like me to drop you off?" And he said, "I think you can drop me at Barney." Barney Pajana was a very close colleague of his. "Drop me at Barney's mother's house in New Brighton." I said, "Fine." And we drove on. New Brighton was the oldest African township in Port Elizabeth, where I'd grown up, spent my whole life. And as we drove on, there was silence for a few minutes, and then he started laughing. And I said, "What are you laughing at?" And he said, "What I'm laughing at is that you don't know how to get to New Brighton. You don't know how to tell me that." It was absolutely true.
He fingered you. He fingered you.
He knew who I was.
Oh, brilliant! We know that he was arrested and brutally beaten in prison. Were you involved in any legal efforts at that time for his release?
No, I wasn't. Although, in a deep irony, he was detained and he was beaten up in Port Elizabeth, and then he was driven through the night in the back of a van, naked, manacled, brain damaged, to Pretoria, where he was taken to the Pretoria prison, where he died on the floors of his cell. By an extraordinary irony of history, I was consulting with clients who were in a big political trial at that same prison that morning, and I said to one of my colleagues, "That's a Port Elizabeth van that's there. I wonder what they're doing there." It had a Port Elizabeth registration number. And half an hour later, or a few minutes later, the colleague said, "Oh, well, that guy is a security policeman from Port Elizabeth. I know him because I've had him in a trial." And we had been there when Steve was brought in and saw the vehicle and all of that. But I had no involvement in that at all. But it was after the event, it was a very weird feeling having been so close.
I'm sure.
Physically close to him at that time. Very odd.
Just before we move on to the LAC, so the Legal Resource Center, the LRC, I'd like to ask what your family thought about your switch to law from medicine and your involvement in this activism, which was obviously, I think, closer to the mining face, to the face of the mind than your parents were. How did they take that?
Well, they were very good about it. They wanted me to be a doctor, but they could see that I wasn't really into it. When I switched to law, they were very tolerant of it, and they paid for me to stay on at university for another few years to do it. When I joined the Legal Resources Center, my father said, after I'd been there a while, he said, "Well, I can see that what you're doing is very good, and I respect and admire what you're doing, but when are you going to become a real lawyer?" And by real lawyer, he meant somebody who made a lot of money and represented rich people. And I said, "I think this is what a real lawyer is. This is dealing with real people and real issues and so on." And said, yes, yes. But he never, he always, they were tolerant of it. They were a bit puzzled about it. He once came to listen to me cross-examine a witness in a case about bus fares, fares being charged to commuters. And he was astonished to see that I could read a balance sheet and ask questions about it. We came back. We came back to lunch to my parents' flat, and he was completely silent. And I said, "You've said nothing about my cross-examination this morning. What do you think of the hearing?" He said, "Where did you learn to read a balance sheet?" And I said, "That's just one of those things I know." But they were very good about it, and I think they were quite proud of it. Actually,
Michelle's mum would never ask her that question because she's both an accountant and a lawyer. So let's turn to the LRC. Tell us a little bit about the history behind its establishment and the figures who were involved with you in doing that.
Well, there was a history in South Africa of lawyers representing people who were being prosecuted for political offences, and quite a proud tradition, in fact, that a lot of people did get good defences. Not all by any means, but many did. But there was no tradition of systematically trying to use the law or the legal system to change the law. It was all purely defensive work. And so what happened was that a few of us got together, some people who'd been involved in the trade unions, 2 or 3 lawyers, to talk about what could be done about setting up what the Americans were calling public interest law centers. Some of us I'd been to the States and had a look and seen what was going on there. Another one of us had also done that. And it looked like that could be an interesting model. The other key person at that stage was Felicia Kentridge, who was an advocate, a woman much older than me, not practicing as an advocate. She was teaching law. She was the wife of Sidney Kentridge, a very famous advocate. And Felicia and I and a few others had meetings to talk about it, but nothing really seemed to work. We realized what we really needed was a director of great skill and authority, because there were all sorts of legal obstacles to the creation of the center. And she then came to the meeting one day and announced that she'd found somebody. She said she couldn't tell us who it was, but we would be satisfied. I thought that was very cheeky of her, how she could make that assumption. Turned out it was Arthur Chaskelson, who was a preeminent member of the Johannesburg Bar, a national figure in the legal profession. And of course, we were more than satisfied. And once Arthur came on board, Felicia and Arthur and I were really the first 3 professional members of the center. We established the center in 1979, and it grew very rapidly. It grew to, in the 80s, to the point where it had, I think, 5 or 6 offices around the country. I think we had about 120 staff members, and it became quite a large organization. It was a fortunate timing. It happened at a time. I mean, now one can look back and see why this was a convenient time, and it took off. It really exploded.
You obviously went to the bar.
Well, I started off as an attorney. Actually, I practiced as an attorney for the first half of my career. I practiced for about 20 years as an attorney, and then switched to the bar.
To the bar, right? God, that's really, really interesting. So then, when you start the LRC, are you full time there, or do you work in a practice and then do the LRC work part time?
So I was full time. I was the first full time lawyer at the LRC, and almost all of our staff were full time. There were a couple of part timers. Arthur was part time at the beginning and part time at the end, but for the rest, it was full time people. And that was the model was that unless we had people engaged full time in this activity, we wouldn't really be able to develop the strategies and do the work properly.
Yeah, and where did the funding come from for that?
The funding initially came from American foundations, Ford Foundation, Rockefeller Brothers, and Carnegie, and one grant from a major American corporation, the Anglo-American Corporation.
Right.
We never really succeeded in obtaining much funding locally. It was foundations and development agencies, initially mainly US, and then quite a lot from Europe as well, and some from Canada.
Right, and obviously you quickly come under the radar of the government. Let me ask about the advocates that you used in that time before you yourself got up on your hind legs. Who are the advocates who are willing to do this kind of work at that time?
Well, they were the people who were the people on our staff. Here comes my catcher visit. The people on the staff were, excuse me,
What's his or her name?
Tsitsi.
Ah, okay.
The Arthur was the full-time advocate, and he did most of the advocacy. But there were others as well. There was a chap named Mohammed Nafsa, who's now a senior judge in the Court of Appeal. There was Paul Pretorius, who's now leading the evidence at the State Capture Commission, which is going on. Carl Tip, I'm sure I'm leading somebody else. Felicia Kentridge herself did a limited amount of the advocacy. But we had a very solid group of people whom, and that's just the Johannesburg office. In the Durban office was led by Chris Nicholson, who became a judge in Durban, and there were other eminent people in other parts. Well, people who, when they joined us, were like the rest of us, slightly scruffy idealists, and who became quite eminent in the profession over time.
One name I've picked up on is Wim Trengrove.
Yes.
Yeah, he did work for you guys as well. Tell us a little bit about him.
Wim is now really the preeminent advocate in South Africa, and he's been very eminent in the field for a very long time. He joined us in 94 or 95 when our political transition took place in 94. By that stage, Arthur had just retired as the national director, and I'd taken over. And one of the things I wanted to do was establish a constitutional litigation unit, because I had the thought that if we did that work and geared ourselves up quickly, we would be ahead of the pack, and we would be able to dominate what happened in the critical first few years. And so we raised some funding from Atlantic Philanthropies, an American foundation, and we hired Wim, who was in his practice. To my astonishment, he agreed to join us for a limited period, for a year or two, I think it was going to be, 2 or 3. And he came across and he worked he went over to the States and to Canada and the UK and had a look at what was going on and learned a bit about the Constitution. And he came back and he then was with us for an extended period. I wasn't there for most of that period because I left in 96 to join government. But he played a critical role in establishing the constitutional litigation unit, which really became the driver of the post-constitutional work that the LRC did. And he's an outstanding advocate, a very fine human being. I said to Felicia Kentridge, for this I want to set up this unit, and the person we really need is Wim. And she said, well, let's go and ask him. And I said, don't be bloody silly. There's no prospect that he'll do that. He's got other things to do. She said, no, let's go and ask him. And we went and see him. He said, yes, that's a good idea. I'd like to do that, to my astonishment. And he played a big role in it at that time. Yeah.
So we've got a young Geoff Budlender sitting at the back watching all these great advocates. You yourself thinking about becoming one at some point. What was it that you picked up from them? Who are the influences for your life looking at these advocates?
Well, the finest advocate I worked with was Arthur Chaskalson himself, who was utterly meticulous. He was a brilliant and remorseless arguer of a case. He had the ability to analyze and argue in a way which was unflamboyant, undramatic, almost unconfrontational. But he would take the judges down a series of steps of inexorable logic, and they would find themselves where they didn't expect themselves to be. He was an extremely clever man, and as I say, he was the best, as a pure arguer, I think he was the best arguer of a case I've ever seen. He was not a great cross-examiner. He was not given to, although he would cross-examine and effectively when he had to, but as a pure arguer of a case, he was extraordinary. I'll never forget one of the earlier cases we did, a case called Komani, which was about the pass laws. We had an unarguable case. We took it on merely because it had to be argued, but there was authority against it, and it seemed unarguable. But Arthur worked out a new approach to it. He found a new insight, an entirely new angle. So he was so effective that about halfway through his argument, the Chief Justice said to him, Mr. Chaskalson, I think you're leading us down the garden path. And Arthur was terribly offended because he was very proper. He thought he was being accused of something improper. But the Chief Justice could see where it was going, that they was going to a place from which there was no escape. And that was how Arthur would argue a case. He was quite extraordinary. Johan Krichler, who's been on your program.
Yeah.
was also a brilliant advocate with whom I worked. He was a trustee of the Legal Resources Centre. I worked with him mainly when I was still in private practice. He was one of the best advocates I've ever worked with. He was extraordinary.
Yeah. I can well imagine that. So tell us a little bit about the challenges that you faced in the LRC. I mean, in terms of the type of work you're doing and sort of the government scrutiny, the pressures, and the pressures on your family and your friends.
Well, we put ourselves in a very particular space in the profession, and quite deliberately, we acted like traditional lawyers. We wore ties. The men wore ties and jackets, and the women wore dresses. We operated from traditional sorts of offices, not quite traditional, but we in the heart of the city centre, and we conducted ourselves as if we were no different. Quite a deliberate adoption of style, partly because that's what we needed, the protection of the legal profession, and we wanted to put ourselves within it. Partly because one of the things we learned is that, and I remember radical American lawyer friend saying to me, poor people want their lawyers to look like lawyers. They want to think these are not poor people lawyers, these are real lawyers. And so we conducted ourselves quite conservatively, and we selected our cases with care. We took cases which we thought were winnable, and we argued them like lawyers. As the centre grew more effective and better known, it became clear that it was a problem to those in power, but they didn't quite know what to do about it. Subsequently, documents emerged in which there were discussions within the security system about how to deal with us. And they were sort of flummoxed by it. On the face of it, we were just being lawyers. We weren't making political statements. Arthur was quite insistent. He said, look, we should do what we do best, which is be lawyers. Of course, if you want to be politically active, that's your business. But the centre as a whole wasn't going to be politically in the public and high profile. And so the security system couldn't figure out how to deal with us. By now, we're into the 1980s. You have to remember by now, the international campaign against apartheid has become very substantial. There are big sanctions. There's a big sanctions and disinvestment movement going on. Government was desperate to avoid that. And so they had to be careful not to do something which would seem to be regressive or repressive and which might trigger further sanctions and further problems. And so, I mean, I've always thought that if the LRC had been established in the early 70s, which was the time of the 60s, which was a time of great repression and increasing repression, it probably wouldn't have survived. By good luck, we came on the scene at a time when government had to be a little bit careful about what it was doing, and that also gave us some protection. And so there were things that happened. Telephones were bugged. When we had an annual general meeting of all our lawyers and our trustees, and we later discovered that the police had sent somebody to spy on the meeting who was allocated a room by the hotel and recorded the entire proceedings while we were engaged in litigation against the government, and those cases were being discussed. People's car tires were slashed and things were thrown through people's windows. But lawyers, particularly white lawyers, let it be said, were a protected breed to some extent. Many of us were white, and we didn't experience the sort of repression which was experienced, for example, by the people who went to the trade union movement or direct political activism, where it was still pretty tough. Things happened, but it was quite bearable.
One other aspect about the LRC's work I'm interested in is in the training of Black lawyers.
Yeah.
And how did that program come about? And what are your success stories?
That's an extraordinary story. I can't claim any credit for it because I wasn't part of conceptualizing it. It arose from a discussion which Arthur had with an American law professor when he was in the States, a woman named Jane Biko. And the difficulty was that young Black lawyers faced was getting into the profession and making a success of the profession. Was firstly, the profession was overwhelmingly white controlled, and white lawyers weren't in a hurry to hire Black trainees, article clerks. They didn't hire them because they were racist, or they didn't hire them because they thought their clients wouldn't want a Black lawyer. Clients were mainly white, or they didn't hire them for whatever reason. And so getting a foot into the profession was very difficult for young Black lawyers. And when they got there, they were at an immediate disadvantage because they'd been through an inferior school system. in a largely inferior university system. And so for those who were lucky enough to get in, their prospects of making it were pretty slim. They were at an immediate disadvantage. They were often marginal. When they went into one of the firms, they were often marginalized in those firms. And the result was that the black profession was very small and it was marginalized. I can recall when I joined the LRC in Johannesburg in 1979, you could count, I knew all the African attorneys in town. I mean, you could count them on two hands, probably. It was a tiny profession, tiny, maybe a bit more than two hands, but not more than three hands. It was a very small and marginalized profession. And so the idea that emerged was that we would start what was called a fellowship program, which would bring promising young black lawyers onto the staff for a year. During that time, they would do a lot of things. They would learn by seeing and doing. They'd get experience. They'd get some good training. It would be a foot into the profession because they would engage with other members of the profession, and they would then start, we hoped, at the profession having been given a decent shot at making a success of it. And that was exactly what happened. The program was, I think, an extraordinary success. It may even be, I think you could make a case that it was the most lasting consequence. The most lasting consequences of the LRC's work were the fellowship program. There have been people who were in that program who ended up sitting on the Constitutional Court, the Court of Appeal, senior positions on the High Court. They've ended up in senior positions in government. Some have gone into business and made quite a lot of money. And the LRC's greatest single failure was to fail to establish an LRC Alumni Association. If it had done that, it would be a very illustrious body.
Who's who?
Yeah, that's right. And how? There was a time, I think, when there were 3 or 4 people on the Constitutional Court who'd been at the LRC at one time or another, or trustees. And the fellowship program was a tremendous thing. Of course, we were having to learn it as we did it, but it was a real opportunity for young black lawyers to make a mark, to have an opportunity to become really substantial lawyers, which they might not otherwise have had. Yeah. And so it was very important.
I want to turn now to the type of cases you guys did with the LRC. And against the backdrop, I think, uniquely in South Africa, because of your judiciary and that sort of small measure, for repressive regimes, you could actually win cases. Yep. You know, in many countries who have repressive regimes, you go to court knowing you're going to lose. So the question I have to ask you is, how did you guys pick the case? And I've read that, you've had colleagues like Zimmerman, for example, who just wanted to take every case and just cosh it through the courts. But how did you guys develop a strategy on picking the right case to take to court?
There were 2 things, I think, which made it possible. One was that we came in with some predetermined ideas. We knew, for example, that the pass laws had to be a major source of attack. It was one of the pillars of apartheid, and it was one of the things which was one of the most vicious aspects of apartheid. And so we came in knowing we wanted to take on the pass laws. We had some ideas about what to do there, and we worked very closely with a women's organization called the Black Sash, which provided assistance to people who were dealing with the pass laws. They were paralegals, not lawyers, and they saw thousands and thousands of people on a regular. Their throughput was enormous, and so they really understood on the ground what the problems were. They were seeing people's problems every day, and they could give you the people. There was a very brilliant woman who ran it named Sheena Duncan, who had a lawyer's mind, although she was not a lawyer, and she could explain to you in detail. She could teach the lawyers what the law was, and she could put her finger on what the points were which were most vicious, and she could point to where there might be areas of vulnerability in the system. And so we worked very closely with the Black Sash because they taught us, and they were the source of the cases. When we wanted a test case, the Black Sash would help us find the cases because they had the pool of customers. For example, there was a particular case which became a famous case called Rikoto, which was about whether migrant workers could qualify for permanent rights in the city. And we devised the case. In fact, it was a case we'd identified before we started. We spoke to Sheena and said, right, this is what we want. She said, yes, that's the case we want. And she quickly found us a client. a very suitable client with perfect facts. We were very clear that if you want to run a test case, you've got to get the facts right. I don't want to lose on the facts. She found a perfect case. There was an administrative appeal process, and for refusal of those rights, we filed an administrative appeal, and to our astonishment, the appeal was granted, which was a great disaster. It was very nice for the man concerned, but it was a disaster for the rest of us because it didn't establish any precedent. So we said to Sheena, we better find us another case. Sheena found us another client, another perfect client, and we went through the same process, and lo and behold, his appeal was also upheld. We then realized there was someone working in that office who was ahead of us, who was very smart, and we could see what was coming. So we said to Sheena, okay, we want another client, but not somebody in Johannesburg. Let's get somebody from the East Rand, which is next to Johannesburg, and maybe they won't be so smart. And within a very short time, she produced a man named Tom Ricotta, and we lodged the internal appeal against his refusal. The official told us to go and jump, and we were then in court with Ricotta, and Ricotta was the great success. So it was a very careful selection of both the case and the client. We tried to replicate that in other areas where it wasn't quite as simple because there wasn't a black sash with that specialist knowledge and the deep pool of clients. We had a policy we worked very closely with a number of community advice officers which were established, providing support. They were lay people, paralegals providing support and assistance. And the idea was that the community advice officer would be a similar pool of potential clients, so that we could A, identify the problems, and B, find the suitable clients to bring the test cases. And that worked to some extent. The advice officers had other benefits as well. But the model was to immerse ourselves in an area, to make sure we understood what was really going on in the area, and then to look hard for a suitable client to run the test case. So it was finding the facts of what was going on, analyzing the law to see where the weaknesses were, and then finding a case that would enable us to open the space. That was the model.
That's really interesting. Was something that you guys took from the way the ACLU selected their cases in the US?
We'd seen it. I think the organization which was most influential was the Legal Defense Fund of the NAACP.
Yeah, right.
Jack Greenberg, who ran it, became a great friend of Arthur's, and we watched what they had done. And it was they had figured out how to choose. The great skill is finding the gap, then working out what is the how far can you get the courts to go when you go there first. How much will the traffic bear? You can't if you often can't bring the case which will bring you to the end point first. You may have to do it incrementally. Yeah. And what the LDF was so clever at, and what I think we worked out, was how to do it step by step.
And that just takes an amazing amount of judgment, doesn't it? That's the really difficult part, doesn't it?
Yeah. Difficult judgment. Of course, in the meantime, it's not always so easy, because sometimes you just go to court because the case just looks good and you don't have to go through that complex process. In a lot of our cases, we didn't do that. But when we ran campaigns, it involved that thought process of how far can we go that the courts will tolerate it this time around.
Well, before we turn to more mundane matters about practice and how you practice, let me ask you, I mean, 79, you started one of the founders of the LRC, worked there for decades, and then you're now on the brink of Mandela being released, of the walls of apartheid coming down. What did that mean for you?
It was incredible. I mean, I must say, some people said they saw it coming. I didn't see it coming. And it was a most astonishing thing. And suddenly everything that was impossible was possible. We had a government which was led by people who were really, really serious about democracy, really serious about rights. Many of them were people that we knew. Dalla Omar, who became the first Minister of Justice, had been very close to the LRC. There were many other people we knew we dealt with in various ways. And so we had access to those in power and access to the constitution-making process, which was itself important. So those first few years were halcyon years, and you could really make things happen without suing. And that was the beginning of a new difficulty, which was how to maintain an independence from and distance from government, while at the same time being supportive of the new democratic government and working with it to get things done in the right way. And so the first few years, I think, were quite interesting and difficult as to how we got that balance right. I mean, for one of the first cases we took after the new constitution was adopted was a death penalty case. We represented the accused in the appellants in the death penalty case, and the government actually supported the government representative the Minister of Justice was George Bezos, who subsequently worked at the LRC. They supported the abolition. The Attorney General opposed abolition. It was illustrated the strange, paradoxical situation we were in. As we move forward, governments ultimately tend to behave like governments, in my experience, and they became less interested in what we were saying. By then, I was in government, and the relationship became a more normal one. Although there was still, for a very long time, and I don't know whether you can say that today, but for a long time there was the government understood that the LRC was on side. It was trying to do the same things, trying to promote democracy and accountability and the transformation of the society. And so there were opportunities for cooperation. And the LRC had to make difficult choices about that.
Yeah, I'm sure. I mean, I guess it's very easy to clap your hands and say, yeah, everything's great, pack your bags and go home. The difficult thing is to continue to be a thorn in the side. Yeah.
Yeah, very difficult.
Okay, let's turn now to your career and speak a little bit about, the time you're sitting there at the back as an attorney watching these advocates at work. When was your light bulb moment when you realized I should be on my feet?
I was national director of the LRC till 96. Then I went into government as the Director General of the Department of Land Affairs, and I was there for 3 or 4 years. Then when I came back to the LRC, I came back as the director of the Constitutional Litigation Unit. By that time, the rules governing the courts had changed to the extent that it was now possible for attorneys to appear in all courts. They were given the full right of appearance, subject to minor limitations in all courts. And so for 3 or 4 years, I worked at the CLU for the LRC, mainly doing advocacy. I was doing both. I was doing both the attorney's work and the advocate's work. And I did that for 3 or 4 years. I found that I really enjoyed doing the advocate's work. And by then, I'd been at the LRC too long. I'd been there for 20 years, and it was really time to move on. So I took the plunge and joined the bar proper. But the 3 or 4 years that I did as a joint practitioner were very interesting and productive years. And I had, to some measure, become an advocate by then. As I say, I was mainly my own attorney in most of those cases, not all of them.
And what was it about advocacy that you enjoyed?
Well, I didn't have the problem that many attorneys have, that they think they've got a good case and then they get screwed up by the advocate, which is always a problem for the attorneys. I was very lucky. I had brilliant advocates right through, and I never had that problem. But you like to do it yourself. And I think I'd just had enough. I wanted to do something different. I discovered that I was able to do it, and I had a choice. When it was time to leave the LRC, I couldn't stay there for the rest of my life. So I either had to go into an attorney's firm, which seemed like a hellish prospect, or join the bar where you've got some measure of independence and some scope. I liked the fact that you'd have the independence, which you don't really have as an attorney, where you get locked into particular clients. So that was why I made the choice I did.
Right. Well, one other thing I observed about you was a sort of interesting snippet about something you said. You said that the people you've probably learnt the most from are your clients.
Yes.
Yeah, and I'd like to get behind that. Well, what is behind that?
Well, that's the great bit for me, being the greatest drawback of being an advocate, that we're at one remove from the clients. We don't really get to know the clients. The people I really learned from were rural communities who were resisting forced removal from their land, rural African women who were fighting for the vote pre-apartheid, under the apartheid structures, pre-democracy under the apartheid structures, the people who came to see me about the pass laws, the trade union organizers. I learned about South Africa from my clients. They taught me what was actually going on in the country and what it was like to be black and what it was like to be an ordinary South African. And that was a huge learning experience. And it was part of the joy of practice, because then their victories became my victories, became their victories, and their victories became my victories. It was not the distanced relationship which one typically has at the bar, which it's sort of antiseptic, it's sterilized, and you have neither the joys nor the tears. You argue a case. I thought the clients were extraordinary. One of the great cases was the treatment action campaign case for around provision of medicine to prevent transmission of HIV to babies at birth. Incredible clients. There was an NGO which was the main client then, but the human beings behind it were extraordinary. It was a passionate fight which engaged every fiber of your being. Not quite like that at the bar. Not quite like that. So I really miss the clients. That's gone, I'm afraid. Doesn't really, yeah.
So what comes across clearly, I think, is that if one would put the law, the advocacy, all of that on one side, and then the human experience of lawyering on the other, you clearly enjoyed the latter more than the former, more engaged with.
Yeah. Although I have to say, I think by the time I came to the bar, I was quite tired.
Yeah.
And the ability to say, well, I do this and I close my office door and I leave all of this behind me was a great help to me. And so I'm not sure how well I would do it now. I used to be good at immersing myself in the relationship with the clients. I'm not sure that I have it takes huge emotional energy. And I'm not sure that I have the emotional energy now. But it was the most memorable parts of my practice are really the clients as much as the courts. And I don't mean that in a sentimental way, but it was I think back, I think of what the clients have taught me about not just about the society, but also about myself. You learn about yourself in those circumstances.
Very interesting quote as well. I mean, with Stephen Biko and you, where he said you said Steve Biko showed that black people didn't want to be like us, meaning white people.
Yeah.
They wanted to be like them. And I thought,
that was a great shock.
Was that?
That was a great shock.
Yeah.
What? White liberals just thought if everybody was just a white liberal, life would be great.
Yeah. Incredible.
Steve said we're neither black nor liberals, actually.
Yeah.
We're neither white nor liberals. Thank you very much.
Yeah. So let's turn now to your approach to advocacy. You're obviously up on your feet and cross-examining, and your father watching you deal with balance sheets. What's your approach to cross-examination?
I'm not a very good cross-examiner. I don't have I think a cross-examiner needs a sort of an instinct. George Bezos was the best cross-examiner I ever worked with, and he knew what was going on in the witness's mind. He could really read what was going on in the witness's mind and then deal with it from there. I don't have that skill. So my cross-examinations tend to be much more cerebral. I work them out in very great detail in advance because I can't do it by the seat of my pants. And I don't think I'm a great cross-examiner. I can cross-examine when I have to, but it has to be worked out very carefully in advance. And I suppose, like with so many other things, I learned how to do it from Arthur Chaskelson because he was a bit like that also. And I saw him writing out every question, literally.
Is that what you do?
I try to. Well, I plan to. Of course, cross-examination doesn't always go where you expect, and you've got to keep your mind open and so on. But Arthur, because he had inexorable logic, would work out and take the witness from A to Z, and suddenly the witness was suddenly discovered he'd said something which was now devastating, and that's what I try to do.
Right. Yeah. So you sort of work out first, right? Well, legally, this is what I need to establish, and then you do your roadmap with the questions you ask. Okay.
What is it? What is the proposition I want to establish, or the proposition I want to destroy?
Right.
And then how do I get there, step by step?
How do you get there? Yeah. Okay. And what about sort of appeals, points of law? Do you enjoy that more than the trial work?
I do. I enjoy that more, and very much so. And there, I think that the real the real skill, if you can get it right, is how you frame the case.
Right. So tell us about that.
Well, because, one of the things that amazed me as I became a lawyer was to realize that in virtually every case, there are lawyers on both sides who think they're right. 70% of the cases, certainly 80% of the cases. So why do they both think they're right when only one side can be right? And I think it goes to the question of how you frame the case, what you think the case is about, what you identify as the issue in the case. And I think if you can persuade the judge that what you think the case is about is what the case is actually about, you're halfway there. And so I do spend a lot of time thinking about what's the issue that I want the case to decide, because if you can frame the issue, then you can turn the whole case to your advantage. In the Constitutional Court here, they made a rule that you're entitled to 10 minutes of argument uninterrupted. And it's actually quite a useful mechanism, because in 10 minutes, you can tell the court what the case is about and frame it. And if you get the framing, if you frame it correctly, and B, you can persuade the court that your framing is right, then I think you're more than half of the way down the road.
Wow.
And you fail when you don't frame it right. I think that's what it's all about.
And then of course that's precious real estate, that 10 minutes. So you've got to really, really think. And how much time do you spend thinking about what am I going to say in that first 10?
I write it out word for word, and then I write it out again, and then I write it out again. And I take very great care with that, because it's a precious opportunity. You never get that in a court. You usually seldom get it in a court. And you know that as you're talking, they're thinking about the questions, and after the 10 minutes are up, they're going to start asking you the questions. So you've got to really, it's a great opportunity. I think it's a very good rule.
Very interesting, because we don't have that here as yet, but very, very interesting.
The Constitutional Court is the only court in South Africa that does it, as far as I know. And I think it's very clever practice.
Yeah. I think Singapore has a guillotine as well, but I think that includes questions being asked.
Yeah, that's
so
right.
It's like the US Supreme Court, rather than what you guys are doing now, which I think is very different. It's very, very different, actually.
Very different. You have people going forever. Yeah.
Yeah. Oh, don't we? I mean, given the opportunity. So let me ask you now, life as a barrister, you've taken silk, top of your game. What is it that you enjoy most as a barrister now?
I think what I enjoy most is I enjoy trying to persuade a court. The two things I enjoy most are, firstly, conceptualizing the case. Clients come to you, attorneys come to you with a problem, and very often they're very clear about what the problem is, but without any sense of what the route map is for getting to a solution of the problem. And so working out what the case is about, what are the legal questions, and what is the strategy to get home, it's the nicest part of the case, and the most enjoyable part of the case. Because when the light bulb goes on and you figured it out, you feel like $1 million, or I do. I think, I solved it. I solved the problem.
Yeah.
I mean, a case comes in, typically, paper. You get a set of papers for an appeal, particularly. I had one recently, and the papers came in, and I thought, this case can't be won. This is just too bloody difficult. The court will be sympathetic, but we can't win it. And then when I understood the case properly, I thought, oh no, this is actually a case that can't be lost if you argue it right. And that's what's going to happen in that case, as it turns out. You didn't have to be a genius to get it out, let me just say. But the case had previously been argued on the wrong basis. And when you could figure out what the right basis was, you could see, this is very easy.
I'm sure you're being modest.
That light bulb moment is a great moment of pleasure. And of course, then persuading a court. I mean, this is an exercise in conversation and persuasion. That's the other thing I've learned from the good advocates. I think the good advocates don't lecture the judges, they converse with the judges. And I think that's very important.
That's really interesting. Right. Well, we're going to turn now into what we call the sort of quick fire round, where I just ask you a question and just give us the first answer that comes to your mind. My first question is, what did it feel like being called the second most dangerous man in South Africa by the Prime Minister?
Well, I'm glad you have that, because that's the nicest thing anyone's ever said about me. I love it. And the man who allegedly said it, John Foster, who was the Prime Minister of South Africa, was a thug. He was a horrible man. with whom I had personal engagement, and I disliked him. I think we disliked one another equally. So I love that. I think that's marvelous.
It's a nice badge to wear, I think.
Yeah. If he ever said it.
Yeah. If he said it. Well, no, it's reported that he said it, so he said it. Okay, let's just take it.
It's become the truth now. Yeah.
It's become the truth. That's right. Alternative facts and all that. The opponent you respected the most.
I had a case against Wim Tringo. I didn't enjoy that. I don't want to do that again.
Really?
Yeah.
Gosh. Okay.
He won a case which he shouldn't have won. So what can I say?
And who did you learn from the most in your career?
Arthur Chaskelson, undoubtedly. He was a brilliant teacher.
Right. The judge who challenged you the most?
In the Constitutional Court, probably Cato Regan. Surprisingly, she would look at you and ask you a question, and as she opened her mouth, you knew you didn't know the answer. It was, she wasn't making a point, but she said, "I've got a problem. Could you explain this?" And you think,
no,
let's go somewhere else. If she couldn't figure out the answer, then you couldn't. That was for sure.
Right. And what would you say is the most important quality in an advocate?
Probably the ability to listen to the client and to listen to the court. One so often sees people arguing a case and stone deaf to what the court is saying. Very important to be able to listen, I think.
That's really interesting. Can I just follow up from that and just ask you, when you're sitting down, your opponent is on their feet, what do you take a note of?
Well, of things that require an answer, I think it's very easy to duck questions which are raised by the other side because you can't figure out the answer. When you do that, you're done for. And so you've got to again listen and watch the judge. If the judge is hearing it, then you'd better answer it, because otherwise you're done for. And so it's a listening and watching, I suppose.
Pick one case and you straddle both professions as an attorney and as a barrister. Pick one case that you've been involved with which stands out for you.
Well, I suppose preeminently the Grootboom case on the right to housing in 2000, when I was still an attorney, but I argued the case. I actually argued it as an amicus curiae, but it was a seminal case on social and economic rights in our constitution.
Right.
Very difficult case. Constitutional Court keyed up, wanting to decide the case, not knowing where it wanted to go, but not sure how to get there, and in the end, producing a brilliant judgment. And being able to contribute to that was a wonderful moment.
Tell us about a day in the life of Geoff Budlender SC.
Well, at the moment, it's very odd. I sit at home most of the day because of the COVID, but typically I'm in my chambers. I don't see a lot of clients and I don't see a lot of attorneys. I'm working mainly on my own or with juniors, and reading and writing. That's what I do. Of course, then you've got to be in court and prepare and argue. But there's nothing very exciting about the routine of an advocate, I don't think. Well, not my practice anyway. And particularly because I don't do a lot of trial work. I think trial work is different entirely. Mainly applications and appeals, motions and appeals. It's not very dramatic.
Right. Okay. Well, that's all I have, Geoff. And can I just say that's been a riveting hour in, 10 minutes? I've really enjoyed it. I hope you have.
I have, Gopal. Thank you very much. I can't usually get people to listen to me so much, so this is very nice.
Thank you for listening to Advocates, the podcast. I hope you've enjoyed the program. Please follow us on all our social media channels. Leave a review or share this episode. And don't forget to tag us. We'd love to hear from you. Thanks.
Listen to the voices of the advocate.